On that case, the defense has requested a recess.
Okay.
The state would ask,
Microphone, please.
sorry.
Oh.
Can you hear me?
Good morning, Ms. Carter. We're sorry.
Good morning, thank you.
And this is James Birch on behalf of the state. Yes, attorney, I talked to Attorney Andre Smith, defense attorney, who filed entry into this case. He's in Tatnall County today, handling some felony matters, and so he's unable to appear. He told me he was going to file a motion for continuance or conflict. I have not double checked whether he has or not, but the state would request that this case be returned to the division.
I don't know if you see anything, Essence. It probably really doesn't matter. I believe people don't usually lie about being in Tatnall County. So I'm sure he's there. So we're going to return it to the division, Judge. We're kind of down to the end, huh?
Yes, Your Honor.
All right, that'll be further notice. The next one we have is 22 CR 006294C. And that's Saquon Cruz.
Yes, Your Honor, and it'll be the same announcement. Attorney Mormon reached out to me asking for a continuance on this case, and I did consent to that. So the state would request that this case be returned to the division.
All right. Further notice. Next, we have 21 CR 003850G. Jacob, is it Fultz or Fultz?
Fultz, Your Honor.
Fultz, okay,
Good morning, Your Honor.
Good morning.
Willis here from Mr. Fultz.
okay.
Your Honor, my client is a resident of Kentucky at this point in time. We negotiated a resolution of this case that is not going to be to the DUI. And I only say that because we're asking it be reset to a later date for either a plea in absentia or a Zoom plea, if we can do that. I am expecting a baby here in the next couple of weeks, so we're hoping to go past mid-October if possible.
Okay, okay. Expecting a baby, that's a big deal. And the baby will come when you're not expected.
That's exactly right.
You know, they have minds of their own. So let's do this. Do we have another plea calendar for September or no?
No, Your Honor.
We don't. So further notice, just talk to the state. They'll stick it on somewhere and try to get it done, I
This is gonna have
guess.
to be returned to the division, or are we gonna able to handle this in?
Well, if we
ORCA?
get it in September, depending on what your baby decides to do.
Well, I'm expecting that we can get it to September. I'm hoping to take the entire month of September off. is my
Oh,
goal,
okay.
Because my expectation, my baby's gonna be a little bit early like last time. My son was born about 8 days early and I'm expecting the same. So I was hoping mid-October or later, but anytime this year is fine, and we have to go back to division.
Yeah.
But this was a major case before it was sent to ORCA, so I'm okay with wherever it goes.
Well, it'll go back to Mather, and by then, your baby will be here in October-ish, so.
So we could do a DocuSign, maybe
Oh,
sometime
well,
during the next few days, if you want to. I could put that in the case file on the plea paperwork, and that way, whenever it pops up in Judge Mather,
As far as the agreement goes, you mean? Oh, yeah.
we can just
Yeah.
memorialize that agreement.
Sure, let's do that.
And then, I'm sorry,
We are running jury trials for the 27th, the 28th, and the 29th.
Those are
It's
the
possible
last.
to do an add-on just to take that plea and absentia, if you all agree on that.
talking about next week,
Tomorrow will be here next week,
but that's what you're referring to is actually next
I mean,
week.
August, she meant,
like,
yeah.
Right.
like next week.
So the state is fine with that, but I know you wanted a little more time, maybe to get some conditions done or
Yeah,
something.
he was gonna work on getting conditions done.
Okay, so
Because he didn't want to be on probation.
Correct.
one, not.
I know, she was just making sure to say we do have that. Well, if not, it'll go back to the division judge. There'll be calendars to add on. Probably more than what we have access to anyway. I'm sure with Mather, you'll have more opportunities
So
to.
it's really up to you.
Mhm.
Let's you and I handle the agreement in
Yeah.
writing, and then we'll be done. We'll get it on whatever comes up after October 15th.
Mhm.
Okay.
Wherever
That sounds
it lands,
good.
fine with me. That-
Yeah, I'll send you the DocuSign. If you sign it, it's completed. I'll download that file and put it into the Odyssey
Mhm.
on that. And
Yeah,
maybe put
that'd
a
be
note in
great.
there saying what's going on.
That works.
And then it's just up to the next prosecutor to, you know.
We're trying to get technologically savvy here. And so for us to say we have even access to DocuSign is, you know, we're excited to say that. So, let's let them do that, you know, and then that way at least it'll be there.
Thank you, Your Honor.
Okay,
So then this will be returned to the division.
turn to the division,
That
further
you're
notice
understanding.
for a
Yeah,
plea.
okay. All right, I'll send you that document.
All right, congratulations.
Thank you, Your Honor. Can I be excused?
Yes, you may.
Have a great day.
You too. Thank you. Next, we have 21 CR 005430G, Quentin Gresham.
That's my case, Your Honor.
Good morning.
We have no motions on that case. Came down today hoping that we might be able to resolve it today, but we're not going to be able to, so we would just ask that it be returned to the division for trial.
Turn to the division for trial, further notice. Which judge is this?
I'm not sure.
Who's G?
Gee.
Oh, Mather. Okay, thank you.
That's all I have, Your Honor. May I have excuse?
Yes, you may.
Thanks.
See you later. Then we have 20 CR 002161G, Charles Landers.
Your Honor, that case has been continued as I understand it. I request a continuance based on my client having a mandatory work meeting today. So I think that case is being returned to the division for motion to trial.
Turn to the division. That's all I'm saying today.
Yeah.
Being a reporter.
Judge Mather can't wait. That's
I know.
another-
He's gonna be so excited.
Thank you, Your Honor.
All right, thank you. And then I have 20 CR 000500E, Justin Pearson.
Yes, Your Honor. This motion that was filed was an attorney withdrawal. And
Oh.
so there was no substantive evidentiary motions on this case.
And has it been signed?
I believe it has been signed,
Okay.
and so the state would just ask this to be returned to the division.
Okay, all right, and you all are going to get new counsel, Mr. Pearson? Okay, hurry up and do that. All right, you all are free to go. When your new counsel enters an appearance, he or she will know what to do from there, okay? All right, you're welcome. Yes.
I'm perplexed as to why the state is spending Fulton County's money on a resident of Fulton County on a case that's not linkable by them.
I hear that a lot. But the state has the right to do that. This is your son?
Yes.
Yes, and I know how you feel, Dad. He's been charged. These are what we would generally call simple driving offenses, but I do see the DUI, which we take seriously. And so, once you get counsel, they can file some motions and things of that nature to see if they can get it moving along. But I would say, welcome to the Fulton County judicial system. And it is what it is, but, you really do need to get a new attorney since your other one withdrew. And then there's some steps that they will discuss with you to take that may help to move it along a little faster. But and if you look at, well, if you had the calendar, you would see that most of these cases are around the same year as this one. And I see it's a 2018 case. But that is the, general Fulton County, caseload that we have.
This case, all the information during the time when
Pandemic.
sabotaged the computers.
Oh, the hack. Mm-hmm.
The fact that they have already checked out, they know that there was no DUI, there wasn't, I mean.
But again, get your new attorney. And that new attorney can do it. You can advocate all you want for your son. And I have parents here that say, Judge, please help. And I just can't. That's why they have attorneys out there. I don't know why your other one withdrew, but certainly get a new attorney, and there are things that can be done to help come to a resolution or speed it up a little bit. But don't look for the magic wand, because Fulton County has a lot of cases. Okay, so get you a new attorney so they can know what to do. Okay, all right, take care. And then you must be last but not least, Jason, is it Priester?
Yes, you are. Good morning.
Good
Timothy Owens
morning.
On behalf of Mr. Priester, who is here.
Okay. Oh, in the back, okay.
Yes.
This is 20 CR 00297 What are we doing here, State?
Well, Trooper Mullen is here in court with us. We're prepared to go forward on the motions, if the defense wishes to do that.
Ready.
Ready? Okay.
Yeah.
Come on up, Mr. Priester. Is it Priester? I'm gonna make sure I pronounce it correct. And this is the motion in limine?
Yes, Your Honor.
Okay. Right. The cartridge would run out at the opportune time. Ms. Carter, you have the style for position 7?
Yes, Judge.
Okay.
Sticky notes, did that work for you? Yellow?
Hi. Who's up in 2K?
Yeah.
No, I know it's Williams. No, man. I'm trying to send a message. She must be doing something. She usually answers me. The judge, we usually can text while we up here. But I was gonna tell him to tell her to come see me before she leaves out. They may, see what he says. Or if he'll answer you. I know yesterday wasn't hardly anybody. Maybe she'll answer me, but I've sent my 3 and she hasn't answered me. You sent it to me, Essence? Okay. Oh, that's her phone. Okay. Well, I'll let you all go ahead and get started. I will tell you, I just have the first 3 pages, so we're changing cartridges and I'll have the others in a second. But I will at least allow you all to get started. State versus Jason Priester charged with 1 count of DUI under the influence per se. A 2nd count, DUI less safe, 3rd count vehicle to drive on the right side of the road. The offense date is April the 12th, 2019. And this is a motion in limine filed by the defense, correct?
Correct.
Okay. All right, I'll let you go ahead and start. I'll let you go ahead and start. With it's your motion?
It's my motion, yes, we are contesting. In my motion, we've contested the stop.
Microphone, please.
Is it on?
Is it on? Let's see. It may not be on. Hold on.
Thank you.
Okay.
Good morning, Your Honor. May I?
Yes.
Yes.
Mhm.
So in our motion, we contested the reasonable articulable suspicion for the stop. We contested probable cause for the arrest. We contested the officer's qualifications to conduct HGN. And we contested, the reading of the implied consent. We are withdrawing all of our contentions except for the reasonable suspicion for the stop. That's what we're going forward on this morning.
So are you saying, you outlined your motion just now, and then you said you're withdrawing all points except for the reasonable articulable suspicion for the stop?
That's what we're contesting this morning.
Okay, so we don't need to go through probable cause or the field sobriety then?
No.
No, okay,
Okay.
all right.
Good, that helps us. And then we have, is this Trooper Mullen? Mullen?
Yes, ma'am.
Okay. Okay, good. All right.
And we would invoke the rule.
Yeah, that kind of stuff like.
I should have just ran upstairs and printed it.
I guess it may came from a long way.
Okay, at this time, the state will call Trooper Mullen to the stand.
Are there any other witnesses in the room? They've invoked the rule that this may be your mom or something, maybe? Are you with him?
Yes.
Okay, but you're not testifying. Okay, all right, come on up, Trooper. We're Actually, let's see. Do we have does this mic work? We may have to have you over. Is it on? Oh, good. Okay, good. Kind of interesting setup there.
I thought this was a step, so I went.
I know, be careful, please, okay?
Okay, I just-
Oh, yeah, we'll swear him in first.
Raise your right hand. You swear to affirm that testimony you give today in these matters are the truth, the whole truth, and nothing but the truth, so help you. I do. Take your name for the record.
And it's a squeaky chair, so.
It's Trooper Leonard Mullen, Leonard Mullen, Mullen.
Okay, thank you for being here, Trooper. Where do you currently work?
I'm currently employed with the Georgia State Patrol,
And how long have you been working for Georgia State Patrol?
approximately 10.5 years.
Was that 10.5?
Yes, sir.
Okay. And prior to working for Georgia State Patrol, were you employed by any other law enforcement agencies?
No, sir, I was not.
And are you post certified?
Yes, sir.
Okay. Throughout your employment with Georgia State Patrol, what kind of trainings have you had specifically in the area of traffic enforcement and DUI enforcement?
I am A-RIDE certified and SFST certified.
Okay. And have you had the opportunity to be a part of any specific task forces with Georgia State Patrol?
Yes, sir. I was part of the DUI task force, the Nighthawks, which is I was out of the North Division and we're based out of Atlanta. And we patrolled DeKalb, Gwinnett, Clayton, Cobb, and Fulton.
And as you were serving on the Nighthawks, was it common for you to be called in for DUI investigations by other officers?
Yes, sir.
Okay. And when you were called in by other officers, did they inform you of the reason for the traffic stop
Yes, sir.
as a standard procedure?
Yes, sir.
Okay, great. I'm going to skip ahead to the night of the incident. Were you working as a Georgia State Patrol officer on the evening of, or the early morning hours, I guess I should say, of April 12th, 2019?
Yes, sir, I was.
Okay. And what were your duties and responsibilities that morning?
I was patrolling the roads of Fulton County looking for impaired drivers.
Okay. And were you in full uniform to include your badge?
Yes, sir.
And were you in a marked patrol vehicle?
Yes, sir.
Okay. And did you get a call from Atlanta Police Department Officer Fernandez that evening?
Yes, sir.
Okay. And what was the reason for that call?
He had a vehicle stopped that was traveling the wrong way on Peachtree Road. He believed the suspect to be impaired.
Okay. And is that typical operation for you being on the Nighthawks task force?
Yes, sir.
Okay. And did you respond to that specific traffic stop?
Yes, sir.
Okay. And where was that traffic stop located at?
It was Peachtree Road near Shadow Lawn Avenue.
And is that in Fulton County, Georgia?
Yes, sir.
Okay. And did you make contact with a person that you later came to know as Jason Jerome Priester?
Yes, sir.
Okay. And do you see Jason Priester inside the courtroom today?
Yes, sir.
Okay. And would you please point him out for the court by an article of clothing and where he's sitting?
He is sitting to my right. He's in a black shirt and black hair.
Okay. Let the record reflect that Trooper Mullen has identified the defendant.
Okay.
Trooper Mullen, is it against the law, the rules of the road to drive the wrong way on a one-way street?
Yes, sir.
Okay. Nothing further from the state, Your Honor.
Okay.
Trooper Mullen, good morning.
Good morning, sir. How are you?
I'm well. Yourself?
Pretty good.
Good. So when you arrived on scene, was Mr. Priester moving?
No, sir, I believe he was still in his vehicle.
He was still in his vehicle. Was that vehicle stopped?
Yes, sir.
And was it facing in the correct, was it facing in the correct flow of traffic?
Yes, sir.
And did you actually observe this traffic violation?
No, sir.
And so once you arrived on the scene, were the officers and Trooper Fernandez was with the APD, correct?
Officer Fernandez, yes, sir.
Officer-
Yeah, yes, sir. You're okay.
Okay.
Yes, sir.
And so he was in a marked patrol unit,
Yes, sir.
and that marked patrol unit had his blue lights on?
Yes, sir.
And did Officer Fernandez have Mr. Priester's license?
I don't recall.
At that point, was Mr. Priester free to leave?
No, sir.
So your only knowledge of any traffic violations is what Officer Fernandez told you?
Yes, sir.
You have no personal knowledge of what actually happened?
No, sir.
Thank you.
Yes, sir.
All right, okay. Any recross or redo?
Yes, just one question, Your Honor. Did Officer Fernandez tell you specifically to your face the reason for this traffic stop?
Objection, hearsay.
Your Honor, this is a preliminary motions hearing. The rules of hearsay do not apply to this. And it also would be his observations as far as what he heard that night.
What he heard or what he was told?
Still hearsay, and the rules of evidence as it relates to hearsay in a motion to establish a fact, that the rules of evidence do apply. They need actual live testimony.
All right, I will let Officer Mullen testify as to what he knows from his knowledge or investigation of the case, as opposed to, and if that would encompass what he knew after arriving on the scene, because I believe he's already testified a little bit as to what he was informed of when he arrived. So I'll overrule a little bit for the moment and allow a little bit of leeway in asking him what he encountered as he came to the scene.
Okay.
So
Thank you.
maybe rephrase the question a little bit might help.
That's right. Trooper Mullen, were you led to believe that a traffic infraction had taken place by Officer Fernandez?
Objection.
Led to believe. Ask him if he knows what happened and then maybe how he knows what happened. Can we
Okay.
start? Let's
Sure.
take the steps there. I acknowledge your objection.
Trooper Mullen, how do you know that Jason Priester broke a traffic rule of the road?
Objection calls for hearsay.
One moment, Your Honor.
And I sustain the objection at the moment. I think there's a better way to ask the question.
Trooper Mullen, was there reliable communication between you and Officer Fernandez that evening?
Yes.
Okay. And is that reliable communication the reason why you went through with your DUI investigation?
Yes.
And is that the reason why you were called out to the scene to conduct that DUI investigation?
Yes, sir.
Nothing further from the state.
Okay.
And the only but as it relates to that reliable communication, that's nothing you personally observed.
Correct. Yes, sir.
And there's nothing you can testify to that happened, correct?
I would object because he already has testified to that.
Rephrase the question just a little bit. I'm not
And the
sure.
substance of that communication, you didn't personally observe.
Correct. I did not personally observe. Correct.
So you can't testify to the details of what actually happened.
Correct.
Thank you.
And just so that I'm clear, Officer Mullen, you conducted the field sobriety, but not the initial stop, correct?
Yes, ma'am. Correct.
And which officer, we're still printing there, which officer conducted the initial stop?
Yes, Your Honor, that was Atlanta Police Department Officer Fernandez.
Okay. And I believe counsel, Ms. Attorney Owens, defense counsel, you stated that this motion for today is just based on the reasonable suspicion for the stop, correct?
Correct, Your Honor. We're
Okay,
withdrawing all other.
the probable cause and the field sobriety.
Yes, Your Honor.
All right, any other evidence? Now I have the full motion. Okay,
No, Your Honor.
all right. Any other evidence for the state?
No, the state will not call any further witnesses today.
All right, and any other evidence from Attorney Owens?
No, Your Honor.
All right, Trooper Mullen, you're free to go. Thank you.
Thank you, ma'am.
Okay. You ready for closing arguments?
Yes, Your Honor.
As I call it, closing arguments or in trial mode? All right, Mr. Owens, are you going first or last?
I'll go last, Your Honor.
Okay, all right, go ahead, state.
Thank you, Your Honor. It was a very quick motion this morning. Since we only have one issue, I did tailor my direct to not waste the court's time. And similarly, I'm going to just cite one specific case to Your Honor, which outlines what is called the collective knowledge doctrine. Case would be State versus Pennyman, 248, Georgia Appeals 446. It was published in 2001. And the citation I have from that case states, reasonable suspicion for traffic stop may exist based on collective knowledge of police when there is reliable communication between officer supplying the information and the officer acting on that information. And so that's exactly what we have here in this case, Your Honor. APD Officer Fernandez observed the traffic stop and called out the DUI task force, the Georgia State Patrol Nighthawks, as they are informed to do. It's a wonderful resource that we have here inside the city of Atlanta, the DUI Nighthawks task force. Trooper Mullen testified today in court. He had reliable communication from APD Officer Fernandez as to why the traffic stop was conducted. We have the state of Georgia has charged Mr. Priester with driving the wrong way on a one-way street. In this case, it would be count 3 vehicles to drive on right side of roadway. And so, Your Honor, I believe the state has met our burden to prove the reasonable articulable suspicion for the traffic stop today based on the collective knowledge doctrine as outlined in State versus Pennyman. Thank you.
All right, thank you. Mr. Owens?
And Your Honor, yes, Pennyman was a 2001 case. I would cite Edmond, State versus Edmond, which can be found at 297 Georgia Appeals 238. That's a 2009 case. That says the collective knowledge when reliable communication between an officer supplying the information and an officer acting on that information. And that's when the collective knowledge doctrine applies. Doesn't apply in this case, Your Honor. The collective knowledge doctrine applies to an officer who gets information from other officers and then initiates a traffic stop based on that information, that collective knowledge. In this case, there is no collective knowledge. There's only one person who had knowledge of that case, and that person didn't testify. It doesn't apply to after the fact and allow the state to get in hearsay evidence to prove reasonable suspicion. It only allows them to justify reasonable suspicion from the officer who actually conducted the stop. Trooper Mullen did not conduct the stop. He did not have any reasonable suspicion or any competent evidence of any reasonable suspicion of the stop. That knowledge would only come from Officer Fernandez, who did not testify. So we would ask that you sustain our motion, and that you find that there's no reason that the state did not meet its burden of proving that there's any reasonable articulable suspicion for the stop.
All right, I'll take it under advisement and give a ruling in a few days. To council, and I will look over both motion, the motion and the state's, motion. Response rather. Okay. And I'll take it under consideration. Anything else?
No, Your Honor.
Okay, all right, thank
Thank you,
you
Your
so
Honor.
much.
That concludes our business.
If you all, or Mr. Owens, if you want to submit a proposed order, you can do that. Should he send it to you, Essence? Okay, and state if you all want to do the same.
Yes, Your Honor.
That'll help me a little bit. You all both have Essence Smith's email. Make sure you do.
I will before I leave, Your Honor.
Okay. And then she'll send them to me.
Yes, Your Honor, I will.
Okay. It's on printer duty this morning. Okay, it's okay. We understand.
Lot of
Thank you.
responsibility.
Okay, so you all are both free to go, and I will give my ruling in a couple of days.
Thank you, Your Honor.
All right, thank you.
Can you all drop that no motion to sign?
It's for tomorrow.
Mhm. Right, to see what we have for in the morning. Do we just have the the 9:30 and no 1 o'clock, right? Okay,
You have my email. When I confirm, your intentions, if you're gonna go forward with your motions, there's lots of emails on Waldrop and Attorney Burch's. Nice to meet you.
all right, thanks.
Thank you, Your Honor.
All right, take care. Let's see. So it looks like you gave me the 2 copies of the state reviews. And then the email with me. Because these are both the same thing. These are both the same. The state. I don't have the defense counsel. It's working.
It's working now.
Yeah, she got it working. Because it wasn't theirs.
She'll look down at the attorney.